Welcome to the Napa Legal Weekly Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director.
And I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty through the lens of faith based nonprofits. We have some interesting topics for you this week. We're going to be covering a new executive order. There are going to be a lot of executive orders in the coming weeks, I think. So, this order revokes federal funding for programs letting biological men participate in women's sports. We're going to cover the St. Isidore of Seville Catholic Virtual School case, which the U.S. Supreme Court has recently granted cert and is going to hear this term. And then we're going to talk about the proposed amendment to Rule 8.4 of the Rules of Professional Conduct for Attorneys in the DC Court of Appeals. So this is ongoing, very interesting. We were just discussing this off camera. I think the first two will be good legal updates. The third will be more of a little bit of a back and forth discussion. So without further introduction, Mary Margaret, why don't you take it away?
Thank you so much, Frank. We're starting off, as we have so often recently, with another new executive order. This was issued on February 5th, and it's entitled Keeping Men Out of Women's Sports. So, if you've been following this podcast, if you've been following the actions coming out of the White House, your first response might be, well, how is this executive order different than the others we've been hearing? Isn't this kind of what we just talked about? Um, and I think in some ways there's a consistent theme here. It is uses the same language. In fact, actually, this executive order refers to a prior executive order on defending women from gender ideology extremism. But this order is actually interesting in a couple different ways. So the first is just kind of procedurally where this stands. This executive order substantively is tracks very closely with a bill that's before Congress right now and recently passed the House and then will soon come up for a vote in the Senate. And so I think what's exciting about this is it's kind of the White House providing a perspective on it that I think could could lead to the enactment of law, which of course has a stronger kind of influence, stronger political power, stronger legal power than an executive order, a one branch kind of position taken alone. And then the second aspect that I think is very interesting about this executive order is what it actually does. So the statement of policy, the definition section is similar to, or actually even sometimes incorporates by reference, the prior executive orders. But the section 4 is really where the action takes place. So the statement of policy is kind of what we've already seen. But so what is this order actually trying to do? It gives a number of specific, kind of like a laundry list or a grocery list of specific action items that need to be done within 60 days of the date of this order. So by April 5th, the Secretary of State, so that's Marco Rubio, will need to prepare like proposals to advocate for women's sports at the Olympics and at the United Nations. So taking this position to the international level, and I think that is a really that's different. We've really all these priorities have been very domestically focused. I think the United States taking a position on the world stage on these issues is very interesting and I think very promising. And then again, within 60 days of the order, the assistant to the president for domestic policy shall convene representatives of major athletic organizations and female athletes impacted by these policies to promote policies that are fair and safe, as well as consistent with the requirements of Title IX. And then this is where it also gets very interesting. Convene states attorneys general to identify best practices in defining and enforcing equal opportunities for women to participate in sports. This is really big. I think that the kind of like a semi-formal collaboration between the executive branch and the state's attorneys general, I think is really healthy, really promising for democracy, and also very relevant on this issues because it was actually the state's attorneys general who took leadership and really stood for truth during some of the confusion the last 4 years around these issues. And so, most specifically, and it's actually referenced in the executive order, there was the Tennessee versus Cardona case, which was a coalition of states attorneys general challenging a Biden administration federal regulation on Title IX, so educational programs receiving federal financial assistance. And then there was also the recent Skirmety case, which was challenging a Tennessee law that prohibited certain types of surgeries on minors that are related, that are motivated, I guess, by a certain standpoint on transgender issues. And so I think having this collaboration between the executive branch and the state's attorneys general is kind of a new era. I think I've not seen this done before, and I'm really optimistic that this is a great. It's great for subsidiarity to have the people of the states, to have these state leaders coming to Washington and saying this affects the daily lives of the people we serve. It shouldn't be just this issue should not be concentrated in Washington anymore. Um, I was just listening to a really interesting interview between Kevin Roberts, Heritage president, and Jonathan Skermety, who's been a leader on these issues, and they talked about how concentration of power is basically inherently evil, at least in our political context. And so, um, I think kind of spreading this issue out and promoting dialogue is very promising. And so for those reasons, I think this is a really interesting executive order. And then I also think the fact that, 2 months from now, there will be some really specific things some deliverables, so to speak, that will come out of this. And so I think this is both continuing an important theme, but also substantively adding some new dimension to this dialogue.
There's so much I would love to add, but I'll restrain myself for the most part. For one, I would love to hear a debate on the right about this, like the inherent evil of concentration of power, because I'm sure there are some conservative monarchists who would love to weigh in on that, but I do not. But I think that more broadly, I won't touch the substance of this executive order because I think you summarized it all really well. And as we noted in our weekly email, the ideal is that the bill passes Congress and is signed into law as legislation rather than having to rely on these funding changes being done by executive order. This is generally something that I think is very fascinating, especially for the structuralists who really care deeply about separation of powers and who does what. I think some of these issues are going to come to a head, and we might see the Supreme Court weighing in on some really important separation of powers questions in the next year with things like this. Because again, when you have the traditional desire that, right, obviously legislation and the power of the purse in particular belongs to Congress. But then when you have massive spending bills that are kind of being passed by continuing resolutions, it seems that they're quick and not really debated item by item. And then they come through with major budgetary issues that are contradicting the presidential administration's priorities. Um, I think you're going to see conflict. Also, when you see things like what's been going on in the news, I won't get too into it, but lawsuits against executive orders where there are nationwide stays, or where even in one case, like the Secretary of the Treasury was banned from full access to Treasury records. There, I won't weigh in right now because all of this is very early. But like I said, I think a lot of these issues, executive orders versus legislation, or court orders versus political appointees from the president, I think there are a lot of really interesting separation of power issues on the horizon that we're going to probably hear a lot about in the next few months. Um, I guess with that, do you have anything more? Shall we pivot to St. Isidore's?
I would just on the separation of powers and then kind of the convening of state attorneys general, it reminded me a little bit of kind of the constitutional drafting, when the drafting of the Constitution, like, back in 1789 when each state sent, like, a delegate to kind of engage substantively with the issues, and I know we have that with Congress, but at the same time, sometimes I feel like Congress is so focused on federal issues, like Washington issues, and I think actually bringing people who live in the states to, dialogue on the issue of transgender, there's just this reminder, like, questions of gender, sexuality, governance, they're not Washington's issues, they're the people's issues, and so I think there's just some symbolism here that's really refreshing, and like you said, Frank, we could go on about it, but I'll stop myself here too.
No, that's a great point. Bringing the perspective of a state to a federal issue completely disengaged from like the national party platform on that issue is really important, and was lost. Not to go down like a conservative nerdy rabbit hole, but that was the point of the US Senate, right? The US senators were entirely beholden to their state apparatus, right? The state legislator picked the state senate, the US senator, and So like the US senator had no real interest in what the national party thought of him. It was about the state. And so you had this interesting role where the US senators would come in, they only cared. Like Pennsylvania senators were only beholden to the issues that Pennsylvanians sent them there for. The national party meant really nothing to them. But once you directly elect US senators, you've lost that dynamic. So maybe you're seeing like a creative reinstating of that with these states attorney generals getting on board with some of these actions. That's a really interesting point. So with that, we will pivot to the no less interesting St. Isidore case. So, those who are friends or followers of Napa Legal will know that we've been covering and following this issue for some time. I wrote about this, I believe it was at the American Conservative, like a year ago, it was early 2024. Our fellow Dion Kathawa also wrote a blog post on St. Isidore before the Supreme Court agreed to hear it. I believe that was last summer he wrote that. And so I don't want to summarize the basics of the case. I think most people listening are probably familiar with it, so I won't go into too much detail. But the long and short of it, St. Isidore of Seville, it's a virtual school, Catholic, statewide, completely virtual, was set to start in 2024. They contracted with the Oklahoma School Board to become a charter school, which then gives them a contract with the state government and public funding. So the previous state attorney general had supported the virtual school getting charter contract. The Oklahoma governor was clearly on board and still is. Then the new attorney general Drummond came in, thought that this virtual charter school contract with a religious school was unconstitutional, filed suit. We all know where this went. The Oklahoma Supreme Court ruled 6-1 that it violated, I think, both the Oklahoma Constitution, the federal Constitution, as well as the Oklahoma charter school statutes, which said that you can't give these charter school contracts to religious schools. So here we are, given the line of religious exercise cases that we've had over the last few years in the Supreme Court. I was hopeful. I actually disagreed with one or two of our fellows about this. I was pretty optimistic that the Supreme Court was going to hear this, and I'm glad to be right here. So the Supreme Court accepted, I believe it was last month or in mid-January, they granted cert. Uh, there's a lot to say here. So I'm just going to pick a couple highlights. I want to touch on the questions that the Supreme Court has agreed to weigh in on here, and then make a couple of maybe historical traditional points about where I think this could go. So, first of all, the two questions that the cert petition asked the Supreme Court to weigh in on are very interesting. Right. So the first one is whether the choices and actions of a privately owned and run school constitute state action simply because it contracts with the state to offer a free educational option for interested students. Now, this is a technical question of law, but it is an important one, right? Because if signing a virtual like signing an agreement agreeing to be a state charter school turns that charter school into a state actor, well, there are two problems, right? For one, you now don't really have a free exercise claim because you're not a religious school, you're a state actor and you don't have free exercise rights under the First Amendment, right? So it kind of blows up the whole substantive question about the First Amendment here if they are indeed a state actor. But the other thing I would say too is that I would be a little wary of the implications if receiving money from a government contract somehow eliminated or at least lessened your free exercise right by turning you into a public actor, state actor. So I think there would probably be a lot of interested parties who would want to know if the Supreme Court's going to weigh in and say, yeah, if you sign a charter school agreement with the state, you're now a government actor. I think this gets messy in a lot of other realms. And again, that's a complicated question. I don't think it's an all or nothing. Like as soon as you sign the dotted line on a government contract, you're now a state actor, period. But it does muddy the waters. So that will be on the table. But I think the second question is what I want to focus on, and that's the substance of the issue. So the the virtual charter school board as well as St. Isidore's are both parties to this case, and they ask whether a state violates the free exercise clause by excluding private religious schools from charter programs solely because the schools are religious, or whether the state can justify that exclusion by evoking anti-establishment interests that go further than the establishment clause requires. Now, I know that's a mouthful, but I just want to kind of break this down quickly. So this has come up before, most recently in Carson v. Macon, where the Supreme Court basically said that there's kind of a line that where the establishment clause ends, the free exercise clause begins. That might be putting it a little bit too simply, but that's basically what the court came down saying, that to the extent that the establishment clause requires that the government not, take an action to support religion, obviously that's constitutional because you have a constitutional duty not to establish religion. But to the extent that you're not establishing religion, right? If you're not violating the establishment clause, then you're probably already pretty close to the line of violating the free exercise clause. And so I think that's where we fall in this case, that if allowing a religious charter school to sign up and become a government contracted charter school, if that's not an establishment of religion, then it's probably a violation of the free exercise clause. Because what that statute is essentially doing is saying all private schools who want to give an alternative to the public education system are free to come to the table here and to apply for charter school status. Oh, unless you're religious, right? And that's a problem. And the court has said that's a problem. This line of cases from Trinity Lutheran and Espinoza to especially Carson v. Macon has made it pretty clear that if the one thing excluding you from an otherwise generally applicable government program is no religion, no religious schools may apply, or no religious programs may apply, that probably runs afoul of the free exercise clause. So I think that's where we are. I just want to very briefly, actually, Mary Margaret, do you want to weigh in at this point? I have a couple other thoughts, but they can wait.
Keep going, keep going. I think, I'd really like to hear you tie it all together, and then I can give my reaction at the end, but I really think I wanna hear you kind of, like, tie it all together.
Sure. Okay. So just wanted to make sure. So one thing is, I think it needs to be clearly remembered, and I think it's worth. I think I'm probably preaching to the choir with this audience, but I think it's worth pointing this out over and over again. What establishment of religion means, right? Establishment of religion by original meaning, in no way can you say that that means, well, the government can't favor or publicly fund anything with a religious character. That's just not what establishment of religion means, right? Establishment was something very clear. A lot of the religious dissenters who came to this country from England were seeking to leave the establishment of the Anglican Church, right? The Church of England was established, it was government funded, it was excluding other religions. If you were not Anglican, you could be fined, you could be punished. That's what a state establishment is. It's the establishment of one sect or one religion to the exclusion of others. Period. I know that we have a lot of like very complicated jurisprudence weighing in on this, but at the end of the day, that's what establishment means. To say that funding religious schools with government funds is an establishment of religion, that's not right. If Oklahoma signed the St. Isidore virtual charter school, but then started to deny Protestant schools or Jewish schools and said, no, no, what we mean by virtual charter schools is you can be secular or you can be Catholic. Like we'll pay for Catholic school. Then you probably have an establishment clause issue, right? But the mere fact of funding religious schools along with other types of schools, there's no one's going to convince me that this is a reasonable way to interpret what the establishment clause meant. Period. And on that note, I think it's also worth reflecting on what public education traditionally was. And I won't go too deep in. You can read my piece from the American Conservative last year if you're interested. I dive a little deeper into this. We can link to that in the description here, so I don't have to go find the title. But the the public education system, this is, I think, pretty clear history, was essentially non-denominational Protestant education. It started in the original American experiment. You had one-room schoolhouses, you had little privately run educational operations. You didn't have a tax-funded state education system until waves of Catholic immigrants were coming in large numbers and funding very large parochial schools, right? The Catholics were very good at organizing and funding schools through their parish churches. And so all of a sudden you had these large segments of Catholic immigrants who are now Americans being educated by Catholic religious figures in Catholic principles. And I think a lot of the Protestant establishment, quite frankly, was threatened by this. They thought it threatened the civic health of this country, which was largely non-denominationally Protestant, right? That's mostly the history of this nation's religious founding. Tolerance for sure, but definitely in its culture, very Protestant. And so the first public schools were clearly Protestant schools. Like they weren't sectarian Methodist or sectarian Baptist, but they read from the King James Bible and they prayed the Our Father. I mean, these were clearly not schools that were, had a wall of separation between church and state where no religion would come in the doors of that school. They were publicly funded and they were clearly providing a religious education. It wasn't a sectarian one, but it was a religious one. So sorry, this is one of my soapbox issues, but I think to claim establishment, to claim that, religion has no place being funded in school funding programs, I think that's just very foreign to the American tradition. And with that, maybe I'll take a breath.
Thank you so much, Frank. Yes, this is fascinating, and it's particularly edifying to hear you connect the dots here because I know you've been following this case even before it was in the national headlines. I mean, you plugged in very early on, and so I think your ability to give the arc is very helpful of where it started and where we've gotten, and then the big picture implications I think are fascinating and it's been very edifying, I think, in the last, particularly maybe 4 years, as the judiciary has clarified and corrected some, I think, mistakes. I think we could safely call them misunderstandings around Establishment Clause and Free Exercise Clause, and where for so long Lemon and Smith dominated. Um, Basically all of religious liberty, First Amendment jurisprudence. And now we have so much clarification, whether it's Fulton, Trinity Lutheran, Tandon v. Newsom, and now we'll have clarity from this case as well as more clarity on the release time religious education issues that we spoke with Cody about last week. And so I think it's very encouraging to see the development of the law in this area and a recovery of what I think the First Amendment was always intended to do.
Yeah, I think it's very heartening, right? Lemon is no more. I think we were listening to somebody talk at a conference just the other day saying that, right, Lemon is gone. I think Smith, for the court watchers here, I think that's on the chopping block in the coming years. I think it's a really hopeful time for religious liberty. I'll give one more practical note for the court watchers without weighing in too much on the reasoning, but um, obviously, like all Supreme Court cases, this case needs 5 votes if it's going to go a certain way. And it was announced right when this case was granted cert that Justice Barrett had recused herself without explanation from hearing this case. So, in order for this to get 5 votes, it will need 5 out of 8. That will not include Justice Barrett. There's a lot of speculation. Obviously, she has ties to Notre Dame law and to the Garnets, who have been involved in the St. Isidore formation. So, again, everybody can speculate. She recused herself without explanation. It probably makes sense, but it will practically make it harder to get to 5 just because there are fewer justices weighing in on this case.
Thank you so much, Frank. I think I hope, is the first of many updates along the lines of this case. And so, yeah, there's so much to talk about with the St. Isidore's case. We'll close off with a something a little closer to home here. A new DC Court of Appeals proposed rule that could, among other things, make the defense of religious groups potentially professional misconduct. So there are really two stories here. I think there's a big picture story and then there's kind of the specific story here. And I'll just start by sketching out the big picture story. Um, Over the last, I would say maybe 5 to 10 years, but particularly the last 5 years, there has been a movement among professional licensing institutions to enact kind of coercive policies and that would really exclude a person of faith from a certain area of practice. So, for example, I know some of the nursing boards are requiring their nurses to certify to things that a person of faith would seriously object to, and a number of other controversial policy positions, which, first of all, are not clearly supported by science, but second of all, um, turn over, years of religious belief as well as conscious objections. And so this DC Court of Appeals is an instance in that larger pattern. And so what this specifically does is it's rule 8.4H. It's been popping up multiple times. I mean, I think the first I heard of it was maybe 7 years ago. It's been around popping up for a while, and it would say that an attorney um cannot make distinctions on the basis of a number of factors for any reason really, including and these factors or these characteristics include sex, religion, gender identity, marital status, family responsibility, socioeconomic status. And the proposed rule um it doesn't clarify that these would only be mean spirited distinctions. It doesn't clarify like it doesn't distinguish between a very legitimate distinction and like hostility. And so it's deeply problematic for so many reasons. I mean, there's just simple anecdotes that some of the comments on the rules point out. Something as simple as maybe someone has a real heart for the immigration process. Maybe they have a family background. Well, they can't, in their pro bono practice, prioritize serving immigrants because that would be a distinction based on national origin. And so there are kind of simple examples like that, going all the way down to um, more kind of, I think, traditional First Amendment type representations where you have someone whose faith is leading them to take an unpopular position on some fundamental issues such as marriage or human sexuality, and representing these clients could potentially be considered misconduct. So I think First Liberty provided excellent comments on this, as did the Ethics and Public Policy Center, and they pointed out just as a matter of principle, this um, clearly violates the First Amendment, and they point to a case from 2018 called NIFLA versus Becerra. I think it's the National Institute for like Family and Life Advocates, I believe is the full name. In this case, the Supreme Court was presented with the question of whether professional licensing or professional speech was protected under the First Amendment. And the Supreme Court clarified that most of the time, professional speech is fully protected by the First Amendment, particularly when it has like substance around a particular issue, like marriage, family, public policy, issues around which people of faith could reasonably disagree. And so um, I think this proposed rule, if it were ever enacted, it would, I think, quickly be challenged under NIFLA. I think it would probably be fairly easy to make clear that this violates the Constitution, but it's still kind of a form of harassment. I think it's the dynamic of the process is the punishment. This kind of almost like it instills fear in someone as an attorney barred in this jurisdiction, like, will I still be able to provide for my family? Will I still be able to live my vocation? And maybe this day it didn't come for me, but maybe next time it will. And I think just the fear tactics of kind of threatening someone's livelihood if they don't go along with a particular policy position. It's problematic. It's a pattern. It's not just unique to the law. It's been happening to doctors, nurses, um, pro-life advocates, healthcare professionals, and um, I think that it's just representative of another phenomenon as well, which is this kind of problem of institutional capture. Where an influential institution like a licensing board um, is kind of overtaken by a group of people whose perspective may not represent the country, probably very likely does not, and they're kind of insulated from political accountability. But then, given, as we talked about earlier, this concentration of power, so you have 8 people and simply 5 of them get to decide whether a Christian attorney can practice in the District of Columbia or whether a Catholic nurse can provide care in the city of Chicago. And so I think regardless of how this issue plays out, I hope that free speech prevails here in the end. But regardless of how this issue specifically plays out, this macro problem of institutional capture in the licensing boards needs to be addressed. And in a sense, I almost hope that this case, or I hope that this law, in a way, I could see it being fruitful for this rule to be enacted and challenged, just to put to rest this kind of barrage of harassment that people of faith in the professional fields are encountering. Frank, I don't know if you have any thoughts on this. I know you've been following these issues as well.
Yeah, I think the proposed Rule 8.4 amendments, like you said, have been going on. I remember debates about this when I was still in law school. Um, I mean, I just find it, like you said, it speaks to institutional capture in general and the chilling of free speech in general. But I think it's particularly offensive to the legal profession, where, I'm thinking of like one particular friend of mine who's a litigator, very good litigator, but he takes very controversial cases, right? Like whether it's criminal defense cases that nobody wants to touch, or like civil rights cases that are very politically incorrect and unpopular. And if you want to classify, the positions he takes in the courtroom as harassment or discrimination based on some protected factor, you probably could, because they're very controversial cultural question issues, right? But the legal profession has always taken both sides and litigated very hard questions. And so to say, well, if anybody takes a position or takes does something in their client representation that they should reasonably know is harassment or discrimination, I think you're definitely chilling representation of sometimes marginalized opinions or communities, because sometimes the positions that are taken in court are going to run afoul of the norms and are going to be considered harassment or discrimination, I guess. Lawyers in particular should be given a very wide berth to take controversial positions. If somebody's actually committing harassment or overt discrimination, we already have laws to deal with those things. I don't think there's any reason to put these in professional misconduct rule, other than for the reasons that you said. I don't know how else to you would possibly justify this. Um, the other thing I'll note is that this is the typical unhelpful, like, nebulous language that doesn't actually clarify anything, which you touched on. In fact, I think it gives you cover to say that anything is or is not running afoul of this rule in the same sentence, right? Because if you read this proposed change to Rule 8.4, it says that it's professional malpractice to do anything that the attorney reasonably should know. Again, reasonableness standard based on, I don't know, the reasonable member of the DC bar panel, or the reason, who knows. Um, but reasonably should know is harassment or discrimination based on a bunch of characteristics. So again, there's no clarification. What counts as harassment? What counts as discrimination? I believe like Rachel Morrison and someone else at EPPC pointed this out. The terms are
Yeah.
vague and undefined, so nobody knows what harassment or discrimination even is here. So we don't know. Are we talking about an argument made in court? Are we talking about a pointed comment at opposing party? Like what is this even like? What categories are we even talking about here for lawyers to be aware of? It's not helpful. But then the other thing here is that the same rule also ends by saying that the rule, quote, does not preclude providing legitimate advice or engaging in legitimate advocacy consistent with these rules. So you can't do anything that's harassment or discrimination. Don't know what that is, but you can give legitimate advice or engage in legitimate advocacy. Don't know what legitimate means. I just think would be such a mess. I think you're right. I think this is ripe for First Amendment challenge if it goes into effect. But also this is perfect cover to, like, bring punitive, we're gonna hit you with a professional malpractice, or a professional ethics violation. And if somebody challenges it, we'll say, actually, yeah, that's legitimate advice or legitimate advocacy, and then we can drop it. This rule just contains the ability to go after anyone and then retract it. And the whole point of these rules is to provide clear tests of what lawyers can and can't do ethically, and this does the opposite of that.
That's so true, and I think there's a gravity as well, I think, to, a law like this that kind of it attacks the institution of law, because as lawyers, the vocation of the lawyer is to be a steward of justice, and the greatest lawyers are the ones who at great personal peril have stood against mistakes of the time. I'm thinking of course of St. Thomas More, but also in our own country, John Adams defending the redcoats. No one could have disagreed more with the with the British at that time, but he chose to represent them in order to show that the law is is bigger than partisanship. It's bigger than us versus them. And so to even propose a law like this that undermines and attacks a lawyer's ability to represent clients, or to take on a perspective that isn't the prevailing perspective of the licensing board, um, really, I think, uh, shows a deep first of all, a deep misunderstanding of the profession. The profession is supposed to be apolitical. It's supposed to be focused on first principles and the execution of law. It's justice, and it's a government of laws and not of men. And like you said, Frank, deeply nebulous, vague rules like this make it a government of not just men, but a government of a licensing board. And it's so problematic, and um problematic in its specifics and problematic in its principles. What it's doing is wrong, why it's doing it is wrong. And so I hope that this is the last time that we see this sort of Alice in Wonderland type professional rule proposed, because nothing good's going to come of this.
Yeah, and if I could just I won't prolong it too much, but I think it's worth tying this back to our religious liberty and nonprofit issues in particular, because I think the place where this is gonna chill representation the most is going to be in traditional religious organizations, especially ones that have traditional views on sex and marriage, right? Because I think it you could construe this rule, should it be finalized, to say that, you should reasonably know that it's discrimination to represent, a Christian school or a Christian employer who thinks that like those two men are not married, or things like that will instantly become questions in the minds of attorneys. So, of course, like the folks um, at law firms like ADF and Beckett and Thomas More, they'll continue to fearlessly take these cases. But what about like normal law firms who like sometimes take more conservative or more religious cases? Like a lot of them might want to back off. Like, oh, with this new 8.4 rule, I don't know if I even want to be in that realm anymore. So I think practically you would really see a chilling of average attorneys wanting to get involved in work defending or helping religious organizations. So with that, those were some pretty exciting topics this week. That was a lot of fun, and I know the time just flew here. So I think we will wrap it up. Thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we would appreciate it as always if you would like the podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith based nonprofit organizations.
We'll talk to you all next week. Thank you for joining us, and God bless.